Oh, nope.
Oh, I don't know if I can use dry shampoo. I also just noticed that we did go on live, and no, we're not talking about shampoo today, everyone. Um, Hello, fellow Marylanders. Welcome to Legal Lunch and Learn, a weekly live show where we ask an expert your question on a legal topic. My name is Cindy. I am a staff attorney here at Maryland Legal Aid. My co-host is the director of our community lawyer initiative, Ms. Megan McDermott.
Hi, Cindy.
Our production engineer in the background, working to make sure that everything runs smoothly, is Alec Chase. And joining us today is our expert on family law, attorney Jordan Baker. Hi, Jordan.
Hi, how are you guys?
Pretty good. Our topic today, as I say it with a smile, is child custody. So if anyone has a question about child custody, please leave that in a comment down below. Or if you want to remain anonymous, you can also private message or direct message us. As a reminder, if you do have an immediate legal issue and want to speak with an attorney one-on-one about your issue, please contact us. Our email here is lawyer@mdlab.org. That's that's LAWYER at mdlab.org. Our phone number here is 443-451-2805. For those who do need captions, we do upload these videos to YouTube, and we'll have those linked for you on our Facebook page as well. So you can use the auto-generated closed captions there. And last but not least, a quick caveat: just because you do listen to our legal talks and take some of our legal advice, it does not establish an attorney-client relationship between you, any of the attorney here, or with Maryland Legal Aid. So with all of that out of the way, hello, Jordan.
Hi.
I'm glad you stuck around through all that intro there. So I don't think we had you on the show before. So tell us something interesting about you.
Oh, something interesting?
or you're just backward, or your
Sure.
background. I mean, it's up to you.
Sure. I've been in the domestic law unit at Legal Aid a little over, I think it's been 3 years. And before that, I was at a private law firm for about 2 years, also doing domestic. So, yeah.
So it's great that you do have both, legal experience and private law practice experience. So for those who don't know what kind of domestic law cases that Legal Aid takes, can you just give a few examples, and we'll go from there.
Sure. In terms of domestic law, what we mostly see are divorces and custody matters that, are separate from a divorce. We definitely have seen a few different types of third-party custody cases. And so part of a divorce could include custody, marital property issues, child support, alimony. So we see all different variations of those types of issues.
Yep. And so just as a reminder for folks out there, I know I just said it, if you do need help with one of those issues, make sure you're contacting us. You can definitely speak with attorney one-on-one if you qualify. I'm sorry. You can speak with an attorney one-on-one. You can have an awesome attorney like Jordan represent you if needed, or give you some advice. So help is out there. So let's dive into child custody, Jordan.
Sure.
And so first of all, I think a lot of our audience out there probably think they know what custody means, but it also is a term of art, which is a fancy lawyer way of saying that doesn't actually mean what you think it means. So can you explain to us, what does custody mean in the legal sense?
Sure. And so custody really involves two different types of custody. And what the court would address are those two different types. And whenever you're, filing a pleading, you have to address those two. So the first one is what's called legal custody. The court considers legal custody to be who's making the long range decisions for the child. So that it doesn't include, what are they eating today? What are we doing tomorrow? It includes medical decisions, educational decisions, religious decision-making, those big life impacting decisions. And then the other type of custody is what's called physical custody, and that's where the child will physically live. Both of those types of custody then can be broken down further. And I think this is where it gets confusing, because both, you can either have sole legal or sole physical custody, or there could be joint legal and joint physical custody. So in the legal custody realm, if you have joint legal, that means the two parties would have to make those long range decisions together, not without the other one. If you have sole legal, that means you are responsible for making those decisions on your own. And for physical, it's a little more straightforward. If primary physical is given to one parent, that means that the child will live primarily with that parent. I think sometimes it gets confusing because people think, oh, that means that they'll never see the other parent. And that's not true. If one parent has primary physical, it could be that the other parent still has visits or access. And then what joint physical would mean is that it's more of a back and forth for the child. And it can look a lot of different ways, right? It could mean a child spends a week with one parent, spends a week with the other. Some parents split up the actual week so that the child's with one parent 3 days, maybe with the other parent 4 days. It can kind of look like a lot of different arrangements. So it does get very confusing when you actually break down what custody really means.
Yeah, and I think something to point out to our viewers who are not attorneys is that it's not just about where the child goes from one day to the other. It's also about, the child's future, the decision you might make. So there it is, custody in a very brief overview. So now let's talk about who needs it, who needs to have an order saying, here's the custody. Because I think if you think of a traditional nuclear family, you have two parents, you have the child, they all live together, and obviously you don't have to go to court to get a piece of paper that says, who has custody. So when we don't have a traditional nuclear family, when does someone need a piece of paper or a court order, if you will, to determine that?
Sure. So that's kind of a hard question to answer sometimes, but a lot of times the clients that I've seen when they walk in, maybe their partner and themselves haven't been together in a long time, so they've tried to co-parent, and maybe they've hit a bump in the road, right? Maybe one parent is starting to deny access to the other. Maybe one parent relocated with the child and didn't consult with the other parent. A lot of times, people do try to co-parent without going to court, because honestly, who wants to go to court, right? But there are situations where you can't really get assistance from, say, like the police, if you don't have a court order that says where the child is supposed to be and when.
Yep, absolutely. And I think you did mention earlier third-party custody. I mean, obviously we know what it means, but could you explain it to our audience?
Sure. A lot of times what that looks like is what a third party is someone who's not a parent. And it could be a lot of people. A lot of times it is a grandparent, but I've had a case, for example, where it was a godparent. And in some way, and in whatever the circumstance may be, that third party has become the primary caregiver of that child. And I think it gets confusing. It can't be that person is acting as a grandparent, but that person is truly taken on the parental role. And that a lot of times third parties, because they aren't the parent, they run into issues, maybe getting benefits for the child, housing issues. So that's when I've seen a lot of third parties file for custody, just so they have a court order saying that child is to live with them. So that's kind of how it starts.
Yep. So let's do talk about the process a little, be it third party or one of the parents. So how does this start? So if someone wants to do this without the assistant of attorney, which we do not recommend because we do offer free legal services, and it's free to use, so why not use us? So for a layperson, where do they even start?
Sure. So the process to start a divorce, custody, third party custody, it's all the same. So what you would do is you would file a complaint in the circuit court. Where you file is you can file where you live, where you live or work, or where the other party lives or works. And so that's how you decide where you want to file. And where you file, the process is the same for every county too. So that's the good news. So for example, for a custody case, you would file a complaint for custody. The judiciary has done this great thing where they make forms to file, and they can be found online. Pretty much every clerk's office also has hard copies of these forms, and they make it pretty straightforward with the forms have all the information the court would need to start a custody case or divorce case or whatever it may be. So you would go ahead and...
You're very observant, because sometimes I have people just talk where I'm trying to interject. So before we get further, is there a fee if you want to file?
So there is. I know in Baltimore City that fee is, I believe, $165. So if you're paying the fee, you have to pay when you file. But the good news is there is what's called a request for waiver of prepaid costs. That form should also be in the clerk's office. And what you do with that form is you're asking the court to waive the filing fee based on, and the form, you have to provide what you make, whether that's weekly, monthly, or yearly. And the court has their guidelines for what is waived and what is not. You'll get a court order. It's Baltimore City, you get an order if it's denied. And it usually says how long you have to refile or when your case will be dismissed because you didn't file the fee or you didn't pay the fee. If it's granted, the court then just moves on and processes your complaint and moves on to the next step.
Right. And let's talk about the next step. So now you file something with the court. Let's talk very briefly about service, officially letting the other person know that you started something. How, and we won't get into nitty-gritties, but how do so I now have this thing called a summons from the clerk's office saying, hey, an action has been filed against you, and now I'm responsible for letting the other party know. How do I go about doing that?
Sure. So you have three options. The sheriff will serve the other individual. There is a fee in every county for using the sheriff. So you'll have to pay that. You can send it by certified mail. The key with certified mail being that you have to get certified mail comes with a green receipt, and you will have to submit that green receipt to the court as proof of service. Or you can have an adult who is not you hand serve that person.
Yep. And this is where it does get a little complicated, because you then have to officially tell the court, this is how I served this person, and officially let the court know, through affidavit or certification that, I promise what I say is true and I served this person correctly. And I usually don't talk too much about procedures on these episodes, but I feel like a lot of times we get clients coming to us because they just cannot get the service done correctly. So if you are having that problem, you're stuck at a point where, either the other person is avoiding service, or you just can't seem to get it right, and the court keeps on telling you, you're doing this wrong, but doesn't really tell you how to fix it. Also give us a call. Give us a call, shoot us an email, and we can help you through that process if you do qualify for our service, and it's completely free. So listeners, keep that in mind. So let's move the process forward. Sorry, I'm moving a little bit slow today. So now that you told the other side, here's what I want. I want custody. I want these things. And what happens next? And now the court knows that, hey, everyone's served, everything's proper. Are there hearings? And how does that all work?
Sure. So once the other side files their, answer to your complaint, you'll have an idea of, do they agree with you? Are they going to contest your what you've requested from the court? Which is always helpful. You'll usually have what's called a scheduling conference. For a scheduling conference, it's not a hearing. I always tell clients it's your first appearance before the court. And it's a way for the court to figure out what are the issues here. Is settlement possible? I've had cases that settle at the scheduling conference. If that's the case, you put your agreement on the record and you move on. You'll get a court order. But you don't have to settle that day. It's really the court's way of figuring out what are the issues. Do any court services need to be put in play? And what I mean by that would be like a custody evaluation, maybe a home study, something like that. Is it a highly contested case? That's usually where you see those services. But the thing you will absolutely leave that day with, at least I can only speak to Baltimore City. I don't know I know it's different county to county, but in Baltimore City, you'll leave with your hearing date that day.
And I want to remind people that it's really important to show up for the,
yes.
If
you do not show up, your case will be dismissed.
Yep. What if you get what if you get served? What if you didn't start it and you have this notice from the other parent saying you need to respond? What happens if you don't respond?
Sure. Obviously we always recommend that you do respond, because if you don't, under the Maryland rules, once you're served, you have 30 days from that day to file your answer. If you don't file your answer, the other part, it doesn't mean that the case ends. And I think sometimes that does happen. People think if they don't file an answer, then the case won't go forward. But the other party can initiate a process called default. And without getting too technical, what that means is the other party can make a request with the court. And that request basically says the other party was served on X date. They had until Y date to file an answer. They didn't. And so, and they were properly served. And so I would like this case to move forward and I would want them to be in default. And what that means, essentially, in a nutshell, the case will move on with or without you.
Yep. Do you still get a hearing after the default?
You do. In child custody matters, the court will still have what's called a default custody hearing. You might not have scheduling, right? They won't set you in for scheduling. They won't set you in Baltimore City. I feel like that should be the disclaimer. In Baltimore City, they won't set you in for scheduling or settlement. They'll just fast track it to a default custody hearing. The party in default, of course, can still show up that day. But the point is that it will move forward even if they don't.
Yep. So definitely answer
Absolutely.
if you can, even if it just, like.
Yeah, you should be a part of it, especially in child custody. The court wants to hear from both parties because that's how they make a determination on what is best for the child.
Right. Yep, absolutely. And of course, are there things, so what if you just forgot about, you didn't go to your default hearing, or if you answered, but you didn't go to the custody hearing and the order now has been entered, are there anything you can do to change that?
Well, that's a little complicated.
Get a lawyer.
Yeah, I would definitely say refer to an attorney. Court orders can be modified, but there's an extra kind of hoop you have to jump through, which would be you have to show the court that there's a material change of circumstance that should lead to the change in the order. And that's a big event, right? That has to be a big change that's happened since your hearing. And it's very hit or miss if you'll be able to prove that. It really can't be just that I didn't show up to my hearing. It's one thing I've seen cases where maybe someone truly didn't know something was going on. Maybe they weren't properly served. Then that's different, right? You'll have to be able to show that and show that you didn't have notice. But then that's kind of getting into murky territory.
Right. And it's also why you really should talk to an attorney, because
number one, talk to an attorney.
Yeah.
Come see us.
Yeah, especially when you are eligible for free service. I mean, why not? What do you have to lose, right?
Right.
So let's talk a little bit about what happens. Well, actually, sorry, I was gonna say let's talk about what happens during the custody hearing, but let's even before that. What kind of documents or evidence do you think people should collect or have in order to prepare for their custody hearing?
Sure. So for custody, what the judge will make a determination on is what's in the best interest of the child. And that's a whole line of factors that I'm sure Cindy will get into later. So you'll want to think about, how can I show the judge what, my child's life is like? So what I always recommend is maybe taking pictures of your home, being able to show the common living spaces, where the child sleeps. Do they have a room of their own? Do they have a bed of their own? If they're younger, that might not be the case, but you can show, where do they live? I sometimes think using family pictures is nice, being able to show your family and who is the child we're talking about, because the child typically is not at court, right? So I think that's good. If child support is at issue, the court will always want either recent pay stubs or your tax return to be able to establish what your income is. They want that from both parties, and that's necessary from both parties to establish child support. And, in terms of medical records, if the child has medical issues, you have to kind of consider what records are actually privileged, what are not. If the child has medical issues and you think that the court does need to see those records, that's really when you would maybe come see an attorney, and you can discuss with them, like, how am I able to get how am I able to have these records admitted into court? Because there are extra steps. And usually I would say that's only necessary if there are medical issues at play, because that ties into medical decision making. I think that's the gist. Yeah.
Yeah, absolutely. And I think it's also at this stage, hopefully before this stage, you talk to your attorney or talk to a attorney. Right. And I think it's also, beneficial to have an attorney, if only just to have another person look at, what evidence you bring, and if it's a good idea to bring it in front of the judge for the judge to consider. Always a good idea to have a second set of eyes going, I don't know about that picture where you have all the dirty laundry in the background. Absolutely. I don't know if that's a good picture to use. Yep. And so let's talk a little bit about what actually happens at the hearing. Do both sides get to talk? What kind of evidence, if you will, does the judge consider?
Sure. Beyond, any evidence you may show up in court with, I would say the most important evidence is your testimony. So at a custody hearing that's contested, the court will hear from both parents, whether you have an attorney or not. So in how it works, the plaintiff will go first. You'll testify. You may have witnesses that you want to testify. And then if you have evidence that you want the judge to review, that's when you would tell the judge that. All of that happens whether you have an attorney or not. So what I advise people, if they are going to a custody hearing, maybe to sit down and kind of make a timeline for themselves of, events, the child's life, because the court will want to hear about what's happened, why are you asking for the relief you're asking for, and is the child going to the doctor like he or she should? Is he or she in school? How is he or she doing in school? Which leads me to think, sometimes report cards are great evidence. The court really cares about grades, and they definitely care about school attendance. That's very important. So after the plaintiff has gone, the defendant will have the same opportunity to be heard, call witnesses, submit evidence they may bring. And the length of the hearing really depends on, number of witnesses, those types of factors.
So how do the judges, and I know this is specific to Baltimore City, do the judges make the decision right there, or do you usually have to wait?
Sure, so it depends. It's really up to the judge you're in front of. A judge could make a decision right at the end, and you could leave court that day with an order. Or a judge could say, you'll be getting my decision in the mail. It's really up to that judge.
Yep. So once an order is issued, so either you get it mail or you get it that day. And what can you do if the other party doesn't follow the order?
Sure. So there is a fun process for that. It's called civil contempt. If someone is not following an order, for me, I think the best example that we see a lot is visitation issues. Maybe someone's being denied access, and in an order, they're supposed to have access on a specific schedule. You can file a petition for contempt with the court. Again, judiciary has forms for that. It's a great one-page request. You would explain what the order says is supposed to happen, and then what's happening, right? How are you being denied? What's in the order? The process is very similar to when you're starting a case. You'll file, if the case is closed, there is a filing fee again. You can file fee waiver though. And then the court, instead of what's called a writ of summons, they'll issue what's called a show cause order. What show cause means is that the other party has to basically explain to the court why they should not be in contempt. So basically, why aren't you following the order, right? And the court will issue the show cause, but it'll be sent to the party who filed. And so again, it's your responsibility to serve the other party. And in Baltimore City, the show cause order has your trial date on there. And it also has the deadline for when the other party has to be served. And that's very important. I think a lot of people miss that because if the other party isn't served timely, then the hearing might not happen.
Yep. And what happens at the hearing?
Sure. So at the hearing, typically the party who is in alleged contempt has to explain why they are not. And then typically what happens is that person's given the opportunity to do what's called purging their contempt. That means essentially to make it right. Maybe the parent who's been denied access gets some makeup time. It can look a lot of different. Purge can look different depending on what the situation is. The court in Baltimore City will set a hearing then and then determine, are you in contempt or did you make it right?
And the question on everybody's mind, I'm sure, can you go to jail for a civil contempt?
Well, you can. A petition for contempt can involve a request for jail time. That can be very scary when you see that in a petition. The important thing to know that I think a lot of people don't realize is because jail time is being requested, you do have the right to counsel. And typically that's through the public defender's office. Anytime your liberty is at stake, that is taken very seriously.
Yep, absolutely. And definitely talk to an attorney if your liberties. And that's at that point, definitely talk to an attorney.
You don't want to mess around with that.
You do not. And I think jail time is very real when it comes to people who are, let's say, repeatedly decide to not follow the court order.
Right.
So that's all the questions I have about the process. So I'm going to go ahead and turn it over to Megan for some questions from the audience.
Thanks, Cindy. Hi, Jordan.
Hi, Megan.
So we have a question that came in that's asking about third-party custody, in which there's several kids, so there's siblings. The person wants to know, would there be a separate case for each child? and therefore a separate filing fee, or would there be one, one complaint that they filed for all 3 kids?
Sure, that's a good question. So what is going to determine the answer is if all 3 kids have the same parents, then it can all be one complaint. If the children have any different parents, then yes, that would have to be separate. And so there would be separate cases. And of course, it would have to be separate fee waivers, which I know is a hassle, but it's worth it. So that's what would determine how the organization of the case would be.
Okay, so if the 3 kids have the same mom, but they might have a different dad, that would have to be separate cases?
Correct, yeah.
Okay. Okay, and then another question, for someone who lives in Maryland, but let's say that it's mom lives in Maryland and dad lives in Pennsylvania, and the child has mostly been with dad in Pennsylvania. Would mom have to file in Pennsylvania, or could she file in Maryland?
So the question that mom would have to ask is, where has the child lived for the past 6 months? If child has been living with dad in Pennsylvania for years, then Pennsylvania would have jurisdiction over the child. There's a federal law that, gives us guidance on jurisdiction over children, and that's kind of the rule of thumb.
Okay. Okay, and you and Cindy talked a little bit about sort of why people would want a court order instead of kind of just making these decisions amongst themselves. What about a situation where the other parent isn't around? Do you have sort of a pro and con list that a client might want to weigh whether they should file for custody? I guess this person is concerned that dad hasn't been around and that he would come back in the picture when he hasn't even been around for like 5 or 6 years because of the court hearing, because he'd have to be served and things like that.
Right.
Any strong feelings about that? Does it depend on the case or
yeah,
the
I would say it's case by case. You definitely would have to pro con it. If you're going through the process of serving someone who you might not necessarily know where they are, that's something you have to think about, because the case won't move forward until they're served or other processes are initiated, which all take time. There are processes for not being able to serve someone called alternate service, which is very murky, and attorneys even get confused. But there are options. But before you go down that road, you have to decide, if you ring a bell, you can't unring it. Is it better for you that dad's not around? It's definitely a pro con. And it's hard to say straight, this is what you should do. Because at the end of the day, the person who knows the other party best is you. So you have to, based on what you know about that person, will they contest custody just to, make it difficult? Sometimes there are situations where you still need that court order. And so then it may be worth it. You have to kind of weigh the reason you're filing for custody against what could happen if you do.
Okay. So sort of building off that fact pattern, say it's a similar situation where, dad has been out of the picture for a couple of years, but they never actually got a divorce. So they're still married. Can you file for custody while you're still married?
You
or
can.
do you have to file for divorce as well?
Sure. You do not have to. If you're married, you don't have to file for divorce just to get custody. There could certainly be, life is complicated. So there's certainly reasons you may not want a divorce and you just want to address custody, and you can just, do a complaint for custody. Process is the same. You'd have to serve your husband or wife and initiate the case that way. But you certainly are not limited. If just because you're married does not mean you're limited to custody or divorce.
Okay. And then what about if the reason that dad hasn't been in the picture is because he's incarcerated? Should mom still try to get custody of the child? And if they do file for custody, does dad have to show up in court still, even though he's incarcerated? How does that work?
Sure. So I've definitely had cases just like this. You can still file for custody if someone's incarcerated. For service, you only have one option. It would be the sheriff, and it would be the local sheriff in the county that the individual is incarcerated in. If you have a custody hearing, they do have the father or the mother, whoever is incarcerated, they have the right to be at the hearing, and they will be transported from the facility. But ultimately, the court is weighing the best interest of the child, and someone who's incarcerated in that moment can't be a resource for their child. So yeah, you still would have to serve that person. They have the right to be there. But the best interest of the child is still at play.
Okay. Okay, so this is a question I've had clients ask me, and it's about taxes.
Okay.
So when you have a custody order, can the judge say in the order, can parties decide who gets to claim the child on their taxes? And then what about if you have joint 50-50 custody? How do you decide who claims the child for tax purposes?
Sure. Not a tax expert, but I definitely have had judges, and I've asked judges to address taxes. I've in 50-50 situations, sometimes the parties may take turns, right? Mom claims the child in odd years, dad claims the child in even years. It can look different based on the situation. Typically, what it's based on is who is the child primarily living with. So if your order is silent on taxes, which it is oftentimes silent on that unless you've asked the judge to address it, you then kind of have to turn to the IRS's guidance on how you claim dependent children.
Okay. And then I think this is the last question. This person wants to know why sometimes Child Protective Services, or DSS, I guess, depending on where you are, might be involved in a custody case.
Sure. So what I've seen is a lot of times DSS or CPS will get involved in custody protective orders that involve custody. The court may refer the matters to CPS for an investigation. But ultimately, if the court hears about child abuse or alleged neglect, that's when CPS may get involved. My experience with custody evaluations, in Baltimore City, they have a medical services office where that they will do the investigation. The parties will meet with, typically it's a social worker. They will also, contact CPS and find out if there is a history of CPS. Is there a current ongoing CPS investigation? And that will be part of their report. That's where I see it most often, is when a custody evaluator is referring to a DSS or CPS history.
Okay, thanks, Jordan. I think that's all the questions that we have. So Cindy will come back to wrap things up.
All righty. Thank you, Megan. So Jordan, now that we're at the end, if there's one or a couple maybe things that you would like our audience to know about child custody, what do you think it will be?
Well, number one, it's worth it to talk to an attorney. I think there's a lot of misconceptions about what custody is and what it entails. At intake, we'll see a complaint someone's filed and they only, check the boxes about physical custody, because I think that's what people think of when they think of custody. But legal custody is very important when it comes to a child's life, right? What are the children go to the doctor? Those decisions are very important. The other thing I would say, I think, don't sit on service. The quicker you serve someone, that means your case is going to move forward. I think sometimes there's misconceptions about service, and that they think the court automatically will serve the other party. So I think it's just, goes back to my first point, talk to an attorney so that process can be made clear to you. And that way your case can move forward and then not be dismissed because service wasn't done, or maybe you served someone and you never filed your proof to the court, right? You don't want that to happen. So I guess both my points are the same. Refer to an attorney, and we're here to help you understand the process.
Yeah, absolutely. Thank you so much for that, and thank you so much for talking with us today. So
thanks for having me.
Yeah, absolutely. And we might be bugging you later as we move deeper into family law, but not this year. And
okay.
If you think that's long, this year is about to end. So
that's true.
We're about to move into November. So for fellow listeners, viewers out there, just a quick reminder, next Tuesday is election day. So please go vote. But that also means we will not have a new episode. However, we do have one the week after that. That will be November 10th. So on November 10th, we'll be back and we will be talking about the so fun topic of how to get a protective order. So make sure you tune back in if that's something that you're interested in and ask your questions, and we'll have them answered live by our expert. So once again, thank you so much for watching. If you do find this video useful, please feel free to share. And of course, if you do have a legal issue that you need to talk to an attorney one-on-one with, please contact us. We are here to help. With that said, thank you so much and have a great rest of the week.